Article number 3, Section 3. Yes, that's where it's at. Treason against the United States. Yeah. Shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, yes, or on confession in open court. Now the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood, yes, or forfeiture except during the life of the person attainted, yes. Now, this corruption of blood, yes. Has there been any attorneys right now? Yeah, when you think about it, yes, the forfeiture, it's very similar to this section number 15. Yes, conviction shall not, shall, no conviction, right now, shall work corruption of blood nor forfeiture of estate. Yes. Now, maybe they forgot the forfeiture of estate in the Constitution. Yeah. Maybe they wrote it wrong, or you know how Washington State is. In fact, get me all these individuals that are known as notary publics. Yes, apparently there's 70,000 of them in Washington State. They have their own individual oath about supporting the state laws. Yes, and the state constitution. And if they have any knowledge of this, I'm going to sue them. See, the notary public, yes, is a kind of judicial position where you have the ability, yes, to notarize documents that are admissible in court. Now, I gave you a screen print yesterday about this civil matter. Yes, where I got a civil order. Yes, you did. For child support right now, without durable power of attorney, without jurisdictional law. Yes. And I thought, well, you're obstructing me from being a notary public. Yes, you did. But in a greater sense, yes, you are obstructing. Oh, in the greater sense, yes. Each and every notary public is personally liable for any knowledge of this fraud. Yes. Now, the habeas corpus, yes, in the United States, is a recourse in law challenging the reasons or conditions, yes, of a person's confinement under color of law. Yes. That would mean the confinement, yes, of the restraint provisions of your court orders, yes, that confine me from being able to talk to my sons. Now, you use the color of law to be able to issue these court orders, yes, without the jurisdiction of the Superior Court of Guam regulating the actual contact between Mr. Budnick, his wife, and the kids. But then there's the United Nations marriage certificate. Now, I would say, yes, she did not have subject matter. Personal jurisdiction, and then there's the minors named. Now, a writ, a petition for habeas corpus is filed with the court. Yes, Washington State. That can be any superior court in any county of the state that has jurisdiction over the custodian. And if granted, a writ is issued directly to the custodian. Yes, to bring the confined person before the court for examination into those reasons or conditions. Now, let's say I emailed the Supreme Court of the state of Washington approximately 100,000 times. And they said, we're not going to issue one of these habeas corpuses because of the restraint provisions of myself being confined from being able to talk to you. You're going to prison. You understand right now.